press the Start Broadcast button on the GoToWebinar control panel to allow all attendees to hear you. This system will notify you once you begin your broadcast. The broadcast is now starting. All attendees are in listen-only mode.
Hello and welcome to the Micklin Law Group's monthly webinar series. Today's webinar is 8 tips for men thinking about divorce. For those that haven't worked with me, this is me. I'm Brad Micklin. I'm the attorney and managing member of the Micklin Law Group, which is a law firm concentrated in empowering men and fathers in divorce, custody, and family law matters, with offices in Nutley, Montclair, and Saddlebrook, New Jersey. Next, I want to show you just some of the awards I've been honored to receive. I put these up not to impress you, but to impress upon you that I have been doing this a very long time. I am comfortable and confident in my experience, my ability to guide you through these processes and legal matters, both on a legal and practical matter. And I hope that my experience and guidance will help you for those that are or will find themselves in a divorce in your future. I also have worked as a national media consultant, appearing on Inside Edition, Fox News, Larry King, may he rest in peace, great guy, and many others. Again, just to give you an idea of the wealth of experience that I am bringing to the information I'm providing to you. These clips and many others are also available on my website, MicklinLawGroup.com, in case you're interested in any of these topics or some that I've covered in the past. All right, so let's jump into what you need to know for a man in a future divorce. First, and most important, retain an attorney who concentrates in family law. And that word to specialize, I have to tell them that they have to change this. I made the change, but apparently it didn't get saved. We're not allowed to say specialize in New Jersey unless you're a certified matrimonial attorney, which I am not. I did not see the need to seek the certification. I've been doing this nearly 30 years. But I say specialize or concentrates in family law because you want somebody who is just doing these areas. You want somebody who is trained and focused in spotting the issues and the intricacies of it. Now, maybe not all cases will require such detail and specialty, but I still generally think, absent a cost concern, that is the way to go. I think there's a lot of nuances, even in what you might consider a simple case, that an attorney with a concentration in family law will bring to your case and will guide you much better. So when you go, like I was saying, you want to avoid a general practitioner. You also want to avoid seeking legal advice from your friends or family at different circumstances, especially if you think you're going to have a contentious divorce or a narcissistic spouse, which is, by the way, two of the areas that my firm concentrates in: men's and fathers' rights and litigating against a narcissist. And I say, don't go to your friends and family. People have a large misconception about divorces, and they think all of them are these ugly, throw-down court battles, and they're not. Those are the aberrations, and that's what people are led to believe are the common ones. I always make the analogy to a lawsuit, I don't know, 20, 30 years ago, probably now, what most have heard about, where a woman spilled coffee at McDonald's and got $3 million for burns. And everybody thinks, well, this is what happens. I almost hope I get burned by coffee because I'll get $3 million. But that case is also the aberration, which is why you heard about it. So just like personal injury doesn't work like that, family law doesn't work like you generally heard. You're hearing what people talk about. You're hearing what is the aberration. So don't be terrified thinking that yours is going to be just like your friends, or don't be terrified if you see that your brother went through something and it was horrible, because it doesn't mean necessarily yours has to be. Another reason why selecting somebody with a specialty or concentration is they will likely be more up to date, not just on the changes in the law, but the changes in how it is applied. So up here you'll see, we talk about, for instance, a change in the alimony laws from 2014, which now would be general practice, but you'd be surprised how many people, even attorneys, aren't fully familiar with the change in the law. But more importantly, the law was changed, in my opinion, because it wasn't being applied correctly. And they hoped to codify or to write down things that were in practice that weren't being used. In my opinion, the problem really was that people weren't reading the law and following it. They were saying things like, well, you're married 20 years and you have a discrepancy in income, it's permanent alimony, without looking at the other person's need or ability to earn, or the fact that you might be retiring in 10 years or even 20 years. It was a cookie cutter approach to certain cases that came to haunt a lot of people. So they modified the law or amended the law significantly. But if you're not a family law practitioner, you might not know the ins and outs of the amendments. You might not know what was there before and what the amendment was to understand the change and how to guide yourself and your clients through it. Now, also, we're going through, I believe that there is a general bias towards men in family law, although the laws are gender neutral, as we indicate on my slide that's in front of you now. But historically, men did not get equal custody or full custody at all. They did not get alimony. Women were the stay-at-home spouses. They were the alimony candidates. And roles have changed significantly. I've seen it even in my practice of nearly 30 years, that now men are staying at home and taking care of the children. Women are out earning. Men are presumed now, not in New Jersey actually, but we're presumed to be fit parents. Both parents are presumed to be fit. And we're presumed to be entitled to equal time with our children, which is a new phenomenon. But the problem is you have a lot of old judges that are old-fashioned, that are still on the bench and carry these old-fashioned views that women need to be taken care of and they get custody. So you need to be prepared to face that bias. And having a good family law attorney on your side will help you do that. Next, never sign anything without talking to an attorney. Now, most good attorneys will always encourage you to settle your differences, do it out of court. I believe our job is to tell you the ranges of issues, the potential, and the issues you're going to confront, and then to let you go and decide what you want to resolve. So if I tell you alimony is X dollars and you want to pay Y, that's always up to you. If you want to pay more in child support or less in child support, more in parenting time or less, you can do that. But I believe it's our job to tell you what you're likely to get, even though we never know with certainty and we can't guarantee. But it's good to let you know. Then you go and make an agreement. But never sign the agreement without having your attorney read it. Sometimes what's most important is what's not stated in the agreement. But if you have no experience doing this, you won't know what's missing. You won't know what needs to be included. You also won't know what problems you're going to encounter in your future, and that's where we come in and can help you the most. Select a family lawyer who will not push you to take what I call a traditional parenting time, alternating weekends, a dinner visit during the week, maybe a week in summer. Many believe, men and women, but I see this a lot more with women attorneys, but both to some extent, are also old-fashioned and will try to push you into a situation that is not necessarily the best for you or your child or consistent with what the law says. So don't let them just say, well, you get this, and this is how much you pay in child support, and this is how much your alimony is supposed to be. Choose a lawyer who's going to let you make the decisions with his or her guidance. Additionally, always pick a family law attorney who has trial experience. I always say the best way to settle a case is to prep it for trial. And you'd be surprised, a lot of lawyers don't have a lot of trial experience. A lot of lawyers aren't good at trial, even though they may believe they are, or they may believe it's okay to go to trial without having that skill, and it puts you at a severe disadvantage. If your lawyer is not willing to go to trial, not willing to take the financial risk that you can afford trial, or just not skilled at trial, he or she will likely be forced to compromise your case and your rights long before that to avoid the risk of going to trial. So make sure you have somebody who is experienced and willing to go to trial. Make sure that you understand the costs of it so that you don't get coerced out of it either. Next, you want to consider alternatives to traditional litigation. So why would you want to do that? Obviously, as everybody knows, whether you've been in it or not, litigation is expensive, time-consuming, and draining. The alternatives are always more cost-effective, less stressful, and the best way to resolve a case. So there is mediation, arbitration, collaborative divorce. Now, I'll just touch on these briefly. I do have many other webinars that dive into each of these individually on my website and my YouTube page. Again, my website is Micklin Law Group, MICKLINLAWGROUP.com. I also have a robust YouTube page at Brad Micklin that has many more videos. So, but simply put, mediation is an attempt where you have a third party, usually hired by the two of you, to help you to reach an agreement. I have some issues with commonly how most people mediate. I won't go into it, it's beyond the scope of this video, but I do recommend you watch my videos on mediation to get my impression of that. Arbitration is where you choose a third party to make a binding decision. Arbitration is a great alternative to trial because you typically get the same type of procedure and decision, but without the formality and the cost. But you do give up a lot of significant rights. Again, I can't go into that at length here because it's beyond the scope, but I do have videos on that. I would urge you to choose. And lastly is collaborative divorce. Now, I personally am not a big fan of collaborative divorce because it's thrown around and it's become a popular buzzword. Collaborative divorce is where the two parties believe or agree that they have similar goals and they want to hire professionals, lawyers and experts and counselors and therapists to work together for this common goal inside of a confidential process. And if the process fails, those individuals are now conflicted out and you start with new individuals, new professionals. So while collaborative divorce is a good theory, in my practice, I don't see the right people choosing it. But if you are, I believe you're on the same page with maximizing, the tax consequences, protecting your children, maximizing each parent's time. If you have similar goals like that, collaborative divorce would be a good choice. Again, see my other videos to get more information on those specific areas. So number 3, what should you be doing as preparing for a divorce? Gather your financial and legal documents. And in advance, even if you are not filing for divorce in the moment, or somebody hasn't filed for divorce and you think it's coming, gather financial legal documents. It is the essential first step before beginning a divorce because it's difficult. You might be married 5 years but never thought to keep your documents. You may be married 20 years and electronic storage didn't exist, and you might need a lot. So what do you want to get? You want to get tax returns, bank statements, credit cards, retirements, any other financial documents. If you have premarital assets, you want to find the statements that existed beforehand. Additionally, how did I go back? Additionally, like I was saying, premarital components when there's exempt distribution. If not, you might want to contact the people that were involved, any professionals in the sale or acquisition of your assets. Again, knowing these numbers ahead of time will help both of you. Again, it'll help you spending time in getting the documents, spending time in your lawyer sending out subpoenas to obtain them. And then also, it will help you prepare the case information statement, which is a financial roadmap that is utilized by the courts and the attorneys to decide most of the issues regarding alimony, child support, and distribution of your assets and debts. I have a webinar on the case information statement, what to and not to include. I also have one on child support. It's a very significant document, so you want to spend the proper amount of time preparing for it and using the documents that you acquire beforehand to attach to it to support your document so that it doesn't look like you just took a summary of information and wrote down and made it favorable. Attaching documents evidences that it's accurate. Number 4, understand the tax consequences in a divorce now and for your future. So when is this important? Before you finalize, it's important to understand tax consequences. Depending on the assets, the consequences can be significant, and I generally recommend that you speak not only to your attorney, who generally won't be able to give you tax advice, because most of us are not tax attorneys, although we're well versed in the tax code regarding divorces. You want to go to a tax attorney also. Generally speaking, assets transferred during a divorce have no taxable consequence, but they will have taxable consequences in the future if you transfer or sell or there's a change in the value. So you want to understand that when you're dividing them. So most will just go on the assumption, well, there's no tax consequence in my divorce, so I don't need to worry about it. But 20 years later, there will be, and you may have taken an asset that has a greater tax consequence in the future than you gave away. So you got less than you thought. Another tip, I call it a pro tip. Alimony taxation changed many years ago that it is no longer taxable to the recipient, and it's not deductible by the payer. And that's what everybody thinks, and even lawyers commonly think this. But what many miss is that it still is deductible in New Jersey state income tax. Now, while it's not as significant of a deduction, it's still deductible. But many will say it's not deductible. They use general language and they put it into an agreement that says it's not taxable or tax deductible, and you lose the tax deduction because of the ambiguity or the lack of knowledge. So make a point, if you're paying alimony, to make sure your agreement, the judge orders that it is deductible, at least on the state level. Again, like I said a moment ago, I jumped ahead of myself, that assets transferred do not carry tax consequence, but it's important to note only at the transfer of the divorce, not later at your sale or transfer. And I also have a note that some legal fees associated with the divorce may be deductible. That's few and far between, and again, something that you need to talk to your accountant about. Number 5, seeking shared custody of your children. I know I touched on it in the beginning. It's kind of my soapbox for my practice, but shared custody is significant. And what's most important is to understand the difference between sole and joint, legal and physical. And I tell clients, to some extent, don't use terms, but understand how it works. Understand what you're looking for. Because there's sole and joint, there's legal and physical, there's primary and residential. You'll get confused and tripped up if you ask for one and you really meant the other. So let me just explain it briefly. Sole and joint is obviously one has all where you share it. But legal and physical can be sole or joint, but it doesn't mean equal. Meaning, so if you have sole physical custody, then you have all of the custody. But if you have joint physical custody, it doesn't mean you have equal time. It just means you're sharing time. So you could have one day of parenting in a year and your spouse has 364 and you'll still have joint physical custody. You'll almost always have joint legal custody, which is the major decisions for your child's life: health, medical, educational, religion, residential. So the most important thing, the point, because I don't want to keep going back and forth to different things, sole means total, but joint does not mean equal. So you always have to spell out how joint is going to be represented with decisions and with physical time sharing. You also need to be aware of the best interest standards, which is every time a decision about children are made, it's what is in the child's best interest. Unfortunately, there is not a great definition of what that means. There are examples, but every case is going to change and determine based on its facts. Jersey has a presumption for joint legal and physical. Like I was saying before, both parents are presumed to be fit. They're both equal footing, and it's presumed to be in a child's best interest to have frequent and continuing contact with both parents. But don't let that mislead you to believe that judges come from that position. In my experience, they do not. In my experience, they come from a position still that's archaic, that says a child needs stability and should be with one parent more often, and that is usually the mother. Keep your children out of custody and parenting time negotiations, especially the initial ones, especially young ones. It is never helpful to a child to be put in the middle. Children aren't sophisticated enough to make decisions about which parent they want to live with. Additionally, they're often conflicted so that the parent that they really want to be with or lean towards is the one they testify against because they need to survive, and the other parent is more difficult. They're trying to please the other parent more often. So, or you may think that your child's preference is to live with you, but in front of a judge or in a chambers, in an in-camera interview, they may not actually feel that way or testify that way. So when you're getting shared custody, there are certain things that you need to consider. Make sure that your housing and life and schedules work to accommodate shared parenting. As much as I want to go to bat for all my clients, don't ask me to fight to give you equal time. If you're going to leave your child with a babysitter and mom's or your husband is at home at the same time, that doesn't benefit your child and it's not economical for anybody. Additionally, let your attorney know what your plans are, how you will accommodate it, and how things may change in the future. If you are planning to move, if you think you're going to be remarrying, if you know the child is changing schools or school districts because of the relocation or because you're moving, discuss all this. Figure out how this may impact you and your children and even your spouse, your soon-to-be ex-spouse in the future. The more you consider beforehand with shared custody, the more you will resolve. Now, as I indicated, part of my practice is concentrating in litigating against narcissists. So if you're dealing with a narcissistic spouse, take steps to protect yourself, document communication, record important conversations, so long as you're in a one-party state, which means, like New Jersey, a one-party state's law says only one party needs to consent to being recorded in a conversation, and that is the person that's recording the conversation. That's what Jersey says. Not every state says that. So you cannot record a conversation in another state without that person consenting. In New Jersey, you can. And remember, though, it may be different if you're recording in New Jersey, but somebody who's in a different state. Now you have a conflict of laws. So I always say err on caution. Don't do it. Maintain records of assets you believe that your spouse may have and transfer, may be hiding. You can usually tell this in two main ways. One, old tax returns. They will often have a capital transaction, a capital gain or loss, a taxable interest that showed up and that you no longer see. It may have been liquidated and transferred. Obviously, there's issues of cryptocurrency that I won't go into in this video, but that's a significant asset. And then look for changes in spending, changes in credit cards, bills that are coming in or not coming in any longer, changes in the banking, where the checks are going, things like that. Number 6, negotiating important custody provisions in your divorce agreement. Now, there are countless important custody provisions that you should include to deal with your current and future situations. I'm going to give you a laundry list here, but it's not exhaustive. So what happens in relocation, out of state and interstate? If you, for instance, are in Essex County and you or your spouse may be moving to Camden County, that technically doesn't trigger a change of custody, like it possibly moving out of state would. I'm sorry for the pause. I had a call come in. I had to zero out. Interstate move is a change of circumstance, but not as significant as moving out of state, but the laws are different. So be prepared and write that in case you anticipate, even if you don't anticipate that's going to happen, still think through what should happen in that event. Right of first refusal, meaning if you or the other parent can't have or exercise your custody with the child, you will offer it to the other parent. Schedule FaceTime and telephone calls so that there's not a long absence between parenting time, even if you're sharing equal time. Vacation time, whether it's going to be consecutive or not, school vacations and summer vacations, requirements that you consult with each other on important decisions, as well as vacation schedules and locations, like if they're traveling out of the country. And when you're going to review custody and parenting time arrangements, That's significant because the law says with absent a change, material and substantial change in circumstances, we're not reviewing custody. So you could sell custody of a 2-year-old, and when he or she is 13, you have to figure out what is a now substantial argument. You would think, well, the passage of time. But the law says passage of time is not enough. And I think because everybody would make that argument. So you need something more. Now, generally in that gap of time, there is going to be more, but you don't want to do that. You want to build it in. You have an idea of when schools are going to change. You have an idea of any religious commitments that are going to emerge or ceremonies that are going to take place. Any other significant event or change that you see, you should build that in to review custody. Number 7, protect your business interests, assuming that you have a business. And again, I did a webinar on this, so you can go in at length, but I will just give you some different general tips, like what to do with your business assets. First, business owners should be aware of the risk to their business when going through a divorce, and it's important to consult with a lawyer to ensure that business interests are protected and the assets are properly divided. So, there's a lot. When you're a business owner, first of all, there's the evaluation. If you started it either pre or during your marriage, there's still going to be evaluation. It's important to know, even if you're a one-man shop and you have a truck and you just have some clients that you go to and service, there's still going to be a value to the business. And it may be a significant one. And having to buy out that interest and service possibly a loan to do so can greatly affect your income and your ability to support yourself and your children. So you do need to specifically dive into this issue with your lawyer far in advance to understand the ramifications. You also want to obtain accurate and up-to-date valuations of your business. You might even want to do so before the divorce is filed. Again, it's always good, like I said before, about getting your documents in advance. You want to prepare as much as you can in advance so that you're not blindsided, and you're also not spending a lot of time and money quickly trying to get all of this and get all of this done. And remember, the value of your business is a key factor in determining the value of your marital estate and the amount of support and alimony you pay or receive. For the reasons I said before, is that there's going to be an evaluation. There's also going to be possibly an income that you're found to derive, even if it's not the amount you're taking. Sometimes judges determine how much you could be taking and then set alimony and child support from that, which then also affects the business and the business income, which has a circling effect to affect your income. It's a mess. So trust me, watch my webinar on this if you have a business asset, and talk to your attorney about how to handle and protect your business interests. Now, if your business is owned by the two of you, the court could order that it be sold or divided between you. Accurate evaluation will help you make sure that you receive a fair division. And how is that going to be determined? It's probably the next question, and that's a very deep question also, and that is done largely by an expert. But you want to understand the certain concepts such as goodwill, marital momentum, presumption that both spouses contributed to the marriage, being an originator of the business or rainmaker, active versus passive assets, and how they affect the value of the marital share of the business for equitable distribution purposes. Now, most of these terms are germane to business evaluation. Some of them are much broader, such as active and passive assets, marital momentum, that go more towards the overall divorce processes and equitable distribution. So even those who don't have a business interest to protect should be looking at these assets and understand them. And again, I know I sound like a broken record. I do have videos on all these topics. And 8, which I believe should be the last one since it's 8 tips, is reduce exposure to large support obligations. So what does that mean and how does that happen is probably the question that you're asking. So in New Jersey, the court will consider a variety of factors when determining spousal support, such as length of your marriage, earning capacity, standard of living, and about 13 other factors. You want to minimize your exposure by knowing these factors, discussing them, having your attorney give you some research, watching my videos on it, and gathering the information to prepare. Just because one person comes to court saying, I need $20,000, doesn't mean they're going to get it. but you need to be able to establish why they're not entitled to it. Unless, for instance, you happen to be the one seeking it, then you need to show why you are. That circles us all the way back around to the first or second tip about getting your documents in advance. And now you'll see why that's so important. Additionally, promptly respond to your attorney's communication and treat court deadlines seriously, because if you do not, getting your information in, getting the documents together, meeting the deadlines, these decisions may largely either be made in your absence or they will be made without sufficient information. So what are certain things to understand about your large potential support obligations? First, if you have your spouse stay out of the workforce, it will be considered a joint decision. And this is important because people come to me all the time and they say, I asked my spouse to work for the last 20 years and he or she wouldn't, and that's why we're getting divorced. I shouldn't have to pay alimony. Wrong. You will have been deemed to have acquiesced to that decision because you did not divorce. So the moment that you said out loud or to him or her, I want you to go to work, and he or she didn't, and you did not file for divorce, you acquiesced to that decision. So you can't reconsider that bad decision because you now have to pay alimony. Additionally, bad spending habits are a joint decision. Same reason, unless you weren't aware of it. And even that's still going to be a little hard pressing because many are going to say you had an obligation to find out. If you dug your head into the sand and didn't know, that's unfortunate, but you're a marital enterprise, you're a joint team, and you're going to equally be responsible for that bad decision. Lastly, there are several factors a court must consider in determining support obligations. There is no one formula for alimony, although many lawyers and judges will use one. I even did a video suggesting that there is one, not because of what the law says, but it's because of what people do. However, I do mine differently, which is why I put the video up. Simply put, I'm not going to go at length, but because alimony is not deductible, I look at my client's net income for ability to pay. Most lawyers and most judges don't. But I think if I'm looking at your ability to pay, I got to look at the paycheck you're bringing home, not what the W-2 is going to say. It's just a fiction. But understand the alimony obligations, understand the factors, and again, like a broken record, gather the documents to support or to reject the claim for a large spousal support. With that, I welcome questions. My email is brad@micklinlawgroup.com. I'm obligated to tell you that emailing me a question does not create an attorney-client relationship. My advice cannot be relied upon except to be advertising materials because I don't have all the facts, so I can't have specific answers, and that's what everything in the law requires that I say to you. As I've said throughout this, I believe I have a very robust YouTube page and website. I do that because I love to give resources to people because most don't even know what to ask, especially if you're at the consultation phase and you haven't even started the process. So these resources give you both legal and practical advice. You can go specific to the topic that you're questioning or concerned about. Go to my YouTube page. My YouTube page has a lot more than my website. I'd rather go to my website because it's just better for my SEO. But if you don't see what you need there, go to YouTube and you can just plug in on my page, a 1 or 2 word search, and you'll get a plethora of videos generally on all of those topics or on any of those topics. Lastly, if you want to schedule a consultation with me, call my office at 973-562-0100. I am generally available Tuesdays, Wednesdays, and Thursdays. My staff will always have my calendar available. There's also a link on my website, micklinlawgroup.com, to book a video virtual conference without having the inconvenience of having to call, but then you will be prompted by me in an email to call and complete an intake to make sure that you do qualify for our services. With that, I hope this information helps you if you ever find yourself in this situation, and I do wish you the best of luck if you do. Thanks, and stay safe.